Imagine the scene without preface because the law itself rarely offers one. A person is seated at a table, under oath, answering questions about someone who is no longer alive. This person is not a trustee, not an attorney, not a caregiver in any formal sense. They are a friend, and yet they are here because friendship after death becomes suspicious when property is involved. This is the condition out of which depositions in trust litigation emerge. A grantor has died. A trust has distributed assets in a way that now feels intolerable to someone still living. The law, deeply uneasy with dissatisfaction that lacks a culprit, reaches for a vocabulary that can transform disappointment into wrongdoing. Financial exploitation is among the most potent of these terms. It does not merely allege error, it alleges moral violation. It presupposes vulnerability, asymmetry, and abuse. And once the term is introduced, the deposition becomes less an inquiry than a ritual for locating a villain. The deposition, it should be understood, is not designed to discover the truth of a relationship. It is designed to compress that relationship into legally actionable fragments. Time, contact, presence, and care are extracted from lived continuity and examined as though they were transactions. The friend becomes a data set. The relationship becomes circumstantial evidence. The law, which is excellent at regulating authority, becomes deeply clumsy when confronted with intimacy. In the case before us, the friend spent 12 hours a week with the grantor, 8 hours every Saturday, 4 hours every Wednesday evening. This fact will be recited slowly, repeatedly, until it acquires a kind of ominous weight. The cadence matters. 12 hours sounds like a schedule. A schedule sounds like structure. Structure sounds like control. But this inference is cultural, not legal. Friendship is repetitive. It is rhythmic. It is, above all, boring. The law has difficulty with boredom. It prefers discontinuities, inflection points, moments where something changed. Endurance resists narration. From time, the deposition moves to communication. Several phone calls a day. Calls that arrived while the friend was at work, between meetings, between clients. Again, the emphasis is not on content, but on frequency. What was said is less useful than how often it was said. Frequency can be made to sound like dependency. Dependency can be made to sound like influence. Influence can be made to sound like exploitation. Each step feels reasonable if taken quickly enough. But anyone who has spent sustained time with an aging person recognizes these calls for what they usually are. Not commands, not consultations, not financial instructions, but reassurance rituals. Is today the right day? Did I already tell you this? Are you still there? These calls do not transmit authority. They test presence. They are existential, not transactional. To treat them as instruments of financial abuse is to misunderstand aging itself. Then comes the written record. Years of text messages preserved in their unflattering entirety. Reminders, confirmations, jokes, frustrations, repetitions. Text messages are hostile to grand theory. They show too much. They preserve continuity where the law prefers rupture. To maintain an exploitation narrative in the face of such records, the argument must shift. The absence of coercion becomes proof of subtlety. The lack of instruction becomes evidence of sophistication. Control, it is said, no longer needs to be explicit. It operates through expectation, tone, and emotional gravity. This is influence without fingerprints, and therefore all the more dangerous, or so the theory insists. Hovering uncomfortably over this entire reconstruction is the fact that the grantor had a professional caregiver 40 hours a week. This should matter. Exploitation depends on isolation. Vulnerability must be narrowed until a single figure dominates the decision-making environment. A full-time caregiver disrupts this story. So the story adapts. Isolation is no longer physical, it is emotional. Institutional care provides services, not meaning. The friend provided meaning. And meaning, once reclassified as dependency, becomes the site of alleged abuse. At this point, the deposition begins to ask questions that appear compassionate but function as traps. Did the grantor seem confused? Did they repeat themselves? Did they rely on you? Were you concerned? Each question invites the deponent to cross a crucial boundary, from observation to diagnosis, from description to interpretation, from recounting behavior to declaring incapacity. This is where the law quietly asks the witness to help erase the grantor's agency. But confusion is not incompetence. Repetition is not incapacity. Reliance is not domination. Aging is not illegality. The law knows this in principle, but litigation thrives on implication rather than proof. The accused friend is now being asked to explain a relationship rather than defend an act. There is no single transaction to justify, no document to contextualize. There is only proximity, and proximity must now be explained as something other than care. What is happening here is not merely a legal maneuver, but a cultural one. We are deeply uncomfortable with aging, dependency, and death. We distrust relationships that endure into decline. When someone remains close at the end, and when that closeness is reflected in estate planning, the impulse is to pathologize it. Financial exploitation offers a language that allows us to condemn without acknowledging our own absence. To prepare for such a deposition is therefore not to rehearse defenses, but to understand the transformation being attempted. The deposition seeks to convert presence into power, availability into authority, affection into leverage. Resisting this process requires refusing to participate in that conversion. Describe what happened. Do not explain what it meant. State what you did. Do not infer why the grantor decided as they did. Let the law prove exploitation through acts, not atmospheres. The deepest resistance is conceptual. It is the refusal to accept that friendship becomes suspect merely because death rearranges property. The refusal to allow care to be criminalized retroactively because the law cannot regulate meaning. If financial exploitation occurred, it must be shown in deeds, not inferred from devotion. And if it cannot be so shown, then what remains is not wrongdoing, but the unsettling reality that someone stayed when others did not. If the first lecture described the deposition as a machine for turning friendship into suspicion, then the next task is to slow that machine down and look at its internal gears. Because once you see how it works, once you understand what kinds of facts it feeds on and what kinds of meanings it tries to extract, you are far less likely to participate in your own narrative undoing. Recall where we left off. A friend sits under oath, accused not because of a specific act, but because proximity survived where others receded. The grantor is dead, the trust has spoken, and dissatisfaction now seeks a moral grammar. That grammar is supplied by the concept of financial exploitation. But exploitation in law is not discovered whole, it is assembled, and the deposition is the assembly line. One of the first things the deposition does, quietly, almost politely, is blur roles. The law, in its formal architecture, distinguishes sharply between actors. Grantors decide, trustees manage, caregivers assist, advisors advise, beneficiaries receive, friends exist. But the deposition has no interest in preserving these distinctions. Its interest lies in collapsing them. The friend begins to sound like a caregiver. The caregiver begins to sound like an influencer. The influencer begins to sound like a fiduciary. And suddenly the fiduciary is accused of exploitation. No one announces this slide. It happens by implication, by adjacency, by the gentle suggestion that functionally these roles are the same. They are not. But the deposition proceeds as though social closeness were a substitute for legal authority. From here, the inquiry turns toward vulnerability. Not vulnerability at a specific time, tethered to a specific transaction, but vulnerability as an ambient condition. Aging becomes a cloud that drifts backward over the entire timeline. Late-stage decline is allowed to contaminate earlier periods of decisional clarity. Questions lose their dates. Toward the end becomes a kind of solvent that dissolves chronology. This matters because exploitation, actual exploitation, must occur at a moment. It has a when. Depositions, by contrast, prefer timelessness. Timeless vulnerability is far more narratively useful than episodic impairment. As proof thins, story thickens. This is where narrative begins to substitute for evidence. Instead of asking what was done, the deposition asks how things felt. Instead of transactions, it explores tone. Instead of causation, it explores atmosphere. Frequency of contact replaces direction of action. Emotional reliance replaces financial control. The law's demand for specificity is quietly postponed, while implication is allowed to do the work in the meantime. This is not accidental, it is structural. Atmosphere is easier to construct than proof. Care, in particular, becomes dangerous here. Care produces asymmetry. One person needs more, the other gives more. But asymmetry is not abuse, it is the definition of care. Still, the deposition treats unpaid care with special suspicion. Paid care is regulated, documented, professionalized. Unpaid care is amorphous, relational, morally charged. Its very generosity becomes a liability. Consistency becomes control. Emotional labor becomes leverage. The law, uneasy with gifts it cannot price, treats them as potential bribes retroactively discovered. Documentation does not rescue the situation. Too little documentation suggests secrecy. Too much suggests management. Text messages, calendars, notes, each can be framed as either concealment or orchestration, depending on need. The deposition does not seek records to clarify, it seeks them to narrate. Documentation is never neutral in an adversarial setting. It is clay. Then comes a more subtle pressure, the counterfactual. What should have happened instead? Who else should have been there? What would a reasonable person have done? These are not legal standards. They are moral hypotheticals. They smuggle judgment into a process that pretends to be factual. They invite the deponent to apologize for a reality that simply occurred. Closely related is the motive trap. Did you benefit? Did you expect to benefit? Were you surprised? Benefit is treated as evidence of intent, even though intent must precede benefit, not follow it. Outcome is quietly substituted for causation. The trust's terms become proof of the crime they are meant to describe. Silence, too, is repurposed. Why didn't you object? Why didn't you intervene? Why didn't you report concerns? The beneficiary is retroactively burdened with duties they never had. Friendship is reframed as oversight responsibility. Failure to police another adult's decisions becomes complicity. This is not law. It is moral panic wearing procedural clothing. Even the presence of others, caregivers, advisors, doctors, does not dissolve the narrative. It is merely rewritten. But you were the one they trusted most. This sentence does enormous work. It erases institutions. It flattens social worlds. It creates an illusion of exclusivity where none existed. And once exclusivity is asserted, influence can be imagined as total. All of this places the deponent in a structurally impossible position. Emotional honesty becomes risky. Nuance sounds evasive. Empathy sounds incriminating. The system rewards flatness, precision, and minimalism, not because they are truthful, but because they are resistant to narrative manipulation. The more human the answer, the more material it provides. And this brings us to the central insight that links this analysis to the earlier essay. The deposition is not hostile to wrongdoing. It is hostile to care. It is a tool designed to operate in a world of roles and transactions, not relationships and meanings. When confronted with intimacy, it does not know how to read it. So it translates intimacy into power, presence into control, and devotion into leverage. To understand this is not to become cynical. It is to become literate. The law does not accuse all friends of exploitation, but it will happily recruit a friend's words to build that accusation if they are offered in the wrong register. Preparation, then, is not about defensiveness. It is about refusing to let the law misname what it does not know how to categorize. The previous lecture argued that presence should not be criminalized simply because death rearranges property. This one adds a corollary, that depositions are not neutral mirrors of reality but engines of reinterpretation. To resist them is not to resist the truth. It is to insist that truth remain anchored in acts, not atmospheres, in authority, not affection, in law, not grief.